Oh hi, didn't see you there. It's Vlawg Thursdays, and it would be morally remiss of me not to talk about the subject that everybody's talking about. And as much as I don't want to talk about it, I have to talk about it. It's like, you can't not talk about it. It's a touchy subject because everybody in American politics, oh by the way, I'm going to talk about Paul Manafort and Michael Cohen in case you didn't know. Everybody in American politics has become so polarized that it's almost impossible to discuss an issue without being demonized to one side or the other. I am dealing with it objectively, as a lawyer must, when reading the news and digesting what is going on in the world of politics and everything. Michael Cohen and his plea deal and what he claims to have admitted to in his plea deal, I find to be the most interesting thing from a legal perspective and from a lawyer's perspective in terms of a lawyer's duty towards his or her client. As I'm sure you've all heard now, Michael Cohen has made a plea deal where he confessed or admitted to 8 crimes, and in his plea bargain or his plea deal there's a written statement. He admits to things, and I say admit in scare quotes for the reasons which I'm going to get into in a second, but he admits to things that seemingly implicate the direction of President Trump to direct Michael Cohen to do certain things, the most important of which from the Vlawg Thursdays perspective was to violate campaign finance laws by using campaign money to silence 2 people from coming forward with stories that might have hurt President Trump in his campaign. But the truly interesting thing is, in the CNN article, take it for what it's worth, Cohen admitted that, quote, in coordination and at the direction of a candidate for federal office, presumably Trump, he kept information that would have harmed Trump from becoming public during the 2016 election cycle. And this is what really blows my mind and surprises me and astounds me, and anybody who knows better than me, please comment in the comment section below and let me know what you think of this. Cohen admitted to keeping information from going public that would have harmed President Trump. Cohen is Trump's lawyer, and for this to be a crime for Cohen to have committed would seem to imply that an individual's personal lawyer has an obligation to disclose information of their client that might prejudice them. And it's a very, very thin line where we have a lawyer whose duty is to represent his or her client loyally and fiercely, and to do everything they can in their power that is legal to protect their client. And here it seems that Cohen is now being convicted of, or now admitted to, and is going to be punished for having not disclosed or having prevented the disclosure of information that would have been prejudicial to Trump, who was his client, which seems to run counterintuitive to everything a lawyer is supposed to do for their client. That said, while a lawyer must do everything in their power that is legally permissible to defend and represent the interests of their client, they are not allowed to do certain things which are illegal, which is to coerce witnesses, or to intimidate witnesses, or to tamper with witnesses. Even in pursuit of defending their clients, there is a line that a lawyer cannot cross in terms of vigorous defending of their client's interests and the pursuit of not disclosing or hiding information that would be prejudicial to their client. So a lawyer does not have to voluntarily elect information to opposing counsel to the public that would prejudice their client, but they can't conceal it, they can't destroy it, they can't go out of their way to interfere with witnesses to prevent the disclosure of evidence. And it's a very thin line, but it's one that we're certainly walking here, and I find it very, very interesting, strictly from a legal perspective. The other thing that I find very interesting from a legal perspective is the plea bargain itself. Now think of this. Cohen is agreeing to a plea bargain. That by definition means he's admitting to certain crimes to lessen his sentence. In his plea bargain, he's implicating third parties. I don't care who it is, if it's Trump, if it's whomever, another person on the committee. I don't care who it is. Cohen, in his plea bargain where he is admitting to crimes to lessen his sentence, is implicating third parties. Now, if the prosecution chooses to accept his plea bargain, that is to say that the prosecution can agree to accept the incrimination of a third party who has had no access to any form of representation in the context of this plea bargain. So Cohen, in an attempt to lessen his sentence, can implicate third parties, and the prosecution can choose to accept the implication of third parties. I don't know if they have evidence to support Cohen's claims. I presume and hope that they do, if they're going to accept the Cohen statement above and beyond his word, given Cohen's credibility as an individual and as a lawyer. But it's very interesting because you have sort of the, I think it's called the criminal's paradox, or when the cops are interrogating one criminal and they say, your buddy just ratted you out, so you better rat your buddy out if you want to lessen your sentence. What you have here is Cohen, in an attempt to lessen his sentence, admitting to having committed crimes and implicating third parties to his plea bargain. It seems to violate a certain fundamental principle of justice, but again, this is just my reflexes as an attorney, not necessarily knowing the laws and certainly not knowing the evidence that the prosecution is relying on to even accept Cohen's plea bargain in the first place. those are my reflections on those two issues. Very interesting stuff. I'm going to be following it because I'm curious to know how it goes and where it goes. Manafort, I find nothing of interest in this story other than the fact that you never know what's going to happen when you get in front of a judge or a jury. Everybody says, I want to have my day in court. I want to take my chances in front of a judge or jury. I always told people as a lawyer, you don't want that. Be careful what you wish for, because you never know what you're going to get when you get in front of a jury. I remember reading the news while the jury was in deliberation with Manafort, and the lawyers are saying, we're very confident, we feel good, it's taken them this long to deliberate, it's obviously going to be good news for us. You never know what a judge or a jury is going to come to in their decision. You never know what they're going to say. You never know how hard they're going to come down on you or the other party. It's a crapshoot. And more importantly than never knowing for certain what they're going to say, you don't know the scope of what they're going to say. I had been in front of a judge on, let's just call it question A, B, and C, and the judge, because the arguments got sort of sidetracked, adjudicated on arguments D, E, and F, which were not even there for the day. I once went in court to schedule a trial date, and we ended up in front of a judge having case management that postponed the trial another 6 months. When you get in front of a judge, you never know what's going to happen, you never know where it's going to go, and anybody who says, I want to have my day in court because I want to tell my story, has to be ready for the fact that they may not like the ending of that story, because telling the story is one part, hearing the ending is the last part, and you may not like the way the story ends when you bring it in front of a judge or a jury. What else was there? There was something else that was driving me crazy. Incidentally, by the way, whenever I get into my law vlogs, I'm never going to disclose anything that's not already public, and I'm still not going to give sufficient information to identify anybody. These are going to be like 30,000 foot level anecdotes. But I had a client who was dying to get in front of a judge. They wanted to tell their story. They were sure that they were right. And between you and me, I was sure that my client was right. Commercial tenant, bounced 18 checks in a year, hadn't paid rent in a few months by the time we got to court. We get to court, we lay out the facts. Yeah, the tenant bounced 18 checks in a year. Here are the canceled checks. They're in default now. The judge comes to the conclusion that because the landlord had tolerated so many bounced checks, the landlord had created a precedent whereby the tenant could take for granted that a bounced check would not lead to the immediate cancellation of the lease. To which I responded to the judge, we're trying to free up the court space, not clog it up. I'm not going to come to court every time a check bounces, and so we can't be punished for our good faith. Now, to say I disagree with the judgment would be an understatement, but that is not to say that I don't understand the judgment. It is possible to create a precedent, an expectation through your conduct that then creates, in one person's mind, one expectation, whereas in your mind you have a totally different expectation. All that to say, the practice of law is one thing. Building arguments, getting the facts, doing all these things is one thing. Getting in front of a judge to tell your story, anybody who watches UFC or boxing knows it's dangerous and it's out of your control. When you leave things out of your control, you can't be surprised when they get out of control. Whereas preparing a case, preparing evidence, putting pressure on people to arrive at a settlement, these are things you can control. And you can control a settlement, you can control an alternative outcome that does not rely on the arbitrary decisions of a judge. Manafort is a good case where you realize we saw how that judge in the Manafort case was behaving during the trial, and Manafort must have been encouraged by it because he was railing against the prosecution and criticizing them and mocking them and all sorts of things. Jury comes back and Manafort's guilty on 8 counts. Okay, well that was it. I mean, that's a rant. Incidentally, guys, tell me if there's anything you want me to discuss during these Law Vlog Thursdays or any other time during the week. If there's something that's excessively urgent or newsworthy, we can deviate from our otherwise carved in stone schedule. And that's it. If you like these videos, like, share, subscribe. Tell me what you want me to talk about. Tell me what you don't want me to talk about. When I do these political things, I'm not doing it from a political perspective. I'm actually just doing my best to do it from a factual, educational perspective, and just to shed some insight on both sides, regardless of your political affiliation. It's important to be able to see both sides of the coin, and you know, this Michael Cohen case is a very interesting example where hate Trump as much as you want. It's a very, very interesting thing where the prosecution can be seeking conviction and getting a plea bargain on a lawyer for preventing the public disclosure of information that would have prejudiced their clients. That has an impact that goes beyond political affiliation. The idea that someone can implicate a third party in a plea bargain and that the prosecution can choose to accept a plea bargain that implicates a third party who is not represented or not a party to the plea bargain has implications that go beyond political affiliation. And these are the important things to realize, that you can be biased by political affiliation, but you still have to be able to be willing to understand the situation above and beyond political affiliation. That is it. Peace out.